Welcome to today's session, our yearly event, the Administrative Law Landscape for 2020. Very different this year, of course, with COVID-19. I can't see you all, as I usually do, up at the Treasury building, which we've been doing over the past few years after lunch. Doing it by blue jeans in a room is quite different indeed, but it should work out okay. A few housekeeping matters before we get underway. There is a question and answer function on the right-hand side of your screen, and I encourage you to send through any questions you might have as they arise or towards the end of the session, and I'll do my best to address them. If we run short of time, what I will do is address all those questions in writing subsequent to the session. So I ask you to provide some contact details if you have any questions so that I'm able to get back to you with responses. The session will be recorded and circulated in the coming days. And of course, before we commence, I'd like to acknowledge the traditional owners of the land on which this event is taking place and to pay my respect to the elders, past, present and emerging. Okay, now let's get down to business then today. We have 6 High Court decisions to consider, and we have 6 Supreme Court decisions which I've picked out as useful to consider for the year. Let me just say, in relation to the 6 High Court decisions to begin with, some of them are only marginally relevant to administrative law principles as such, in the sense that they're more in the realm of constitutional law. And at least one of them, which I'll refer to, is not about public law at all, but it is about statutory interpretation, and that is an issue of emerging and continuing importance for us. So I thought it was important to refer to that decision, even though it's not in the public law sphere. I'll probably try to go fairly quickly through the decisions that I think are of marginal relevance to administrative law at the federal level. I should say as well that this year at the High Court level, which I'm talking about really, there haven't been as many cases on general principles of administrative law that there usually are. And the ones that have emerged are mostly in the realm of the highly statutorised fast-track review process under the Migration Act, which means that I think there are limited lessons we can draw from them in terms of general principles, but we'll talk about that as we go through. Let's just start with the High Court decisions, which I've picked out as important, and quickly running through the ones probably of less importance to us at the state level, but still important nationally, of course. The High Court decision in Love against the Commonwealth was an important one in 2020, as you'll probably remember, because it concerned the reach of the aliens' power, and it essentially said that the aliens' power does not reach Aboriginal Australians. Key facts were, of course, that both of the plaintiffs in this case have been convicted of serious offences under Queensland law. They faced deportation under the Migration Act. Both were born outside Australia and were citizens of another country. But here was the key point. Both were descendants of or were identified as members of particular Aboriginal people, and one was part of a group of native title holders. This case went as a special case stated for the High Court, and it was a contentious 4-3 majority split, in the sense that the majority concluded that Aboriginal Australians cannot answer the description of aliens under Section 5139 of the Constitution, the alien's power. Now, without going into a lot of detail, the key argument, I think, in this case is based on Mabo number 2, the native title case. The key argument for the majority stemmed from Mabo number 2. At the time of European settlement, common law recognised that Indigenous inhabitants held antecedent rights and interests in the land and the waters. That connection gave rise to what some of the judges referred to as a deep spiritual connection with country, which the Crown was obliged to protect, and the analogy was drawn from that in relation to the reach of the alien's power. The three judges in the majority strenuously disagreed with that approach. They thought it was erroneous to analogise and apply the common law development of native title law, constitutional questions about the reach of the alien's power. Justice Gageler thought as well that it introduced an element of race that should not be there. So it was a contentious decision, and I'm sure you're all aware of that. At the time, there was a lot of press coverage of that case about the High Court being too adventurous or going too far in its decision-making process. More a constitutional case, as I said, so we'll move on from that. Another one, again, not so relevant to general principles of administrative law, but one which received a great deal of attention in the press, was Smethurst against the Commissioner of the Australian Federal Police. Smethurst was a journalist, you might remember, who published a number of articles which were critical of proposed amendments to national security legislation, which would have authorised covert access to data held not just by foreigners but by Australian citizens. She had somehow got access to ministerial submissions made about the proposed amendments, and that put her in a potential breach of provisions of the Crimes Act. As a result, search warrants were taken out, not just against her but against others, of course, and they were activated against her property. Special case stated to the High Court again, of course, the end result of which was that the High Court determined that the search warrants were invalid. They did so on the basis that the search warrants did not adequately articulate and refer to and describe the particular offences in question for which the evidence was being obtained. Again, as I said, not direct relevance to us in terms of administrative law principles as such, but some general broad pronouncements by the court about the importance of the rule of law and the manner in which it seeks to protect individuals from unlawful search and seizures historically in the common law. And in that sense, those principles underpinning the result that they came to. The search warrant was invalid on that basis. That was a unanimous decision, but there was a 4-3 split as to whether or not the court could issue a mandatory injunction requiring that evidence be delivered back to Ms. Smethurst or destroyed. The majority said that there was no basis for an injunction in that respect. Part of the reasoning pointed out that in Australia, even unlawfully obtained evidence may still be admissible in a court. There's a test that's applied without going into the realm of evidence and partly criminal law, so that for all we knew, the evidence obtained might still form the basis of some prosecution potentially. So there was no identifiable legal right or interest requiring the court's protection in that sense. A contentious conclusion, particularly in the eyes of the minority who argued that there was, and there's reference made to the importance of privacy and the tort of trespass as a possible supported basis for an injunction. But that was the outcome of the decision. And as you probably recall, some of the other journalists who were subject to search warrants were not able to overturn the search warrants in respect of the actions taken against them. But moving on from that, the High Court decision in Hocking against the Director-General of the National Archives of Australia is a little closer to administrative law. I suppose we could say FOI in a sense, although it's really about provisions of the Archives Act, the partner piece of legislation to the Commonwealth FOI Act. Again, you'll remember the controversy surrounding this case in the lead-up to the High Court case. Professor Jenny Hocking, the historian, had been attempting for approximately 5 years to seek access from Australian archives to the dismissal papers, the letters generated between the Governor-General Sir John Kerr and the Queen, or the Queen's private secretary, Sir Martin Charteris at that time, relevant to the lead-up to the dismissal. Those letters had been deposited in 1978 with the Australian Archives by Mr David Smith, the then official secretary of the Governor-General. And when he deposited the letters, he gave an instruction that they were Sir John Kerr's papers and that they were not to be made available publicly for public access until after 8 December 2037. The Palace later reduced that to 2027. But the real point in this case was whether or not they were documents subject to the provisions of the Archives Act, because if they were, they would need to be made available in the open access period, which in this case, given the date of their lodgement, would be 2006 to 2008. So if she won the case, then Archives would be required to process her Archives Act application. Australian Archives was previously saying, we don't need to process it because they're not Commonwealth records. So the case turned solely on the construction of the statutory definition of a Commonwealth record in the Archives Act. As I've set forth in the PowerPoint here without going through in all the detail, that's referred to as a record that is the property of either the Commonwealth or a Commonwealth institution. Commonwealth institution is defined to include the official establishment of the Governor-General. The High Court reasoned that the word property meant that referred to someone who has lawful power to control the physical custody of the record, which they said was satisfied in this case. The High Court unanimously came to the, well, not unanimously, I'm sorry, by a 6-1 majority decision. Justice Nettle dissented here in concluding by majority the letters were the property of the official establishment of the Governor-General. They constituted a Commonwealth record, each of them. I guess the interesting point was, what about the fact that when the official secretary lodged them, the official secretary said, these are personal letters of the Governor-General, they're not to be released until a certain date. Well, the High Court just rode straight over that and said, well, be that as it may, we're interpreting the provisions of the Archive Act, which apply to Commonwealth records and specify what's to happen. So irrespective of what the official secretary in person said at the time they were lodged, the relevant provisions of the Archive Act govern the relationship between the Australian Archives and the letters, and as a result, a writ of mandamus would issue compelling the Director-General of Archives to deal with Professor Hocking's application and also to pay her costs in respect of the action. And as you probably know, she got access to the letters that generated a book she wrote, in which her argument was that the Crown, the Queen, was aware of the steps involved leading up to the dismissal. Two other journalists wrote a book, Kelly and Bramston, journalists with the Australian newspaper, wrote a book saying in their view that the Queen was not personally aware and that the only people who were aware of what was going on were the Governor-General and Sir Martin Charteris, the personal secretary of the Queen, but that was kept, that what was going on was kept from the Queen. So that'll be an ongoing controversy. But I think that's an important decision in terms of the concept of Australia as an independent nation, controlling its own documents, I suppose, in this case. The next case I want to talk about is, briefly, is Australian Investment and Securities Commission and King. This is a decision which is really not to do at all with public law, but it is to do with statutory interpretation, and particularly since the High Court decision in A2 a couple of years ago, the High Court decision involving female genital mutilation, the High Court has been emphasising a new, what you could almost call a new approach to statutory interpretation, text, context and purpose, an approach which is much more amenable to the idea that you can place emphasis on context and purpose, and you're not so constrained about looking at extrinsic material in reaching a decision. So I just want to refer to the King decision in that context. The case dealt with those provisions of the Corporations Act, which are on your screen. Just jumping to the facts, Mr. King was a director of a parent group of companies, which included responsible entities underneath it. He wasn't a director of one of the responsible entities companies. He was a director of the overarching parent company. But he was involved in controlling what the responsible entities did. And in this particular case, one of the responsible entities entered into a loan agreement and ultimately used the money for impermissible purposes. Trial judge found that the responsible entity company had contravened section 601FD, just going back to that PowerPoint there that you can see, in that there was no care and diligence exercised in relation to the activity. But the question was whether or not Mr. King was also knowingly concerned in the case and would be liable as an officer of the company. So going back to the PowerPoint there, you can see officer of the responsible entity. Well, he wasn't an officer of the responsible entity, but the general provision in Section 9 defines officer of a corporation to mean either A or B, either a director or a secretary of the corporation, which he wasn't, or someone who has the capacity to significantly affect the corporation's financial standing. The Queensland Court of Appeal said, well, he could only be liable under 9B2 if he was an actual officer of the responsible entity. But the High Court reversed that and said, no, the Court of Appeal overlooked textual differences between 9A and 9B2, as you can see there in that PowerPoint. It wrongly departed from a literal application by adding a requirement that an officer could only be someone holding a designated office in the relevant corporation, and 9B2 provides a broader reach than that. And the High Court went on to consider context and purpose and spent a lot of time looking at the amendments leading up to the Corporations Act in its present form in order to show that there was always an intention to catch people, if you like, who were not specifically officers or did not specifically hold office in the relevant corporation but could somehow influence its actions. So I think it's just an important decision in terms of statutory interpretation. Just looking at my watch and making sure we move on quickly, and I realise I'm probably going pretty quickly, but I'm trying to spend a bit more time on the decisions of greater relevance for general principles of administrative law. Some of these PowerPoints look horrible, I know, because they look too busy, but all I can say is read them later at your leisure if you don't mind, and I'll try and deal with them in broader terms as we go through. CNY 17, yes, it was 2019, but it was handed down after I did last year's presentation, so I want to pick it up and refer to it because it is an important decision on the bias rule. It does involve the fast-track review procedures under Part 7AA of the Migration Act, which is a bit of a pity for us. It's a highly statutorised process, which often produces a number of decisions before the High Court, as I said before, most of which turn very particularly on the relevant provisions and specific facts. But this one does say some general things about the bias rule. Under that process, the relevant statutory steps, the Minister's delegate made a decision refusing a visa. The fast-track review process requires that the Department give the Immigration Assessment Authority, the IAA, the review material and require it to immediately review the decision without taking on board any new material or interviewing the applicant, except where special circumstances justify that. And in this case, the key point was that the review material sent up to the IAA contained some extraneous and prejudicial material, presumably by the look of it, reading between the lines, just by accident. It looks like material that was contained in the file was just sent up to the IAA without a closer look and without taking it out before it was sent to the IAA. Now, given that the IAA's duty is to review the material, to make a decision on the review material, then in that sense it has before it the relevant material about the decision and the reasons for the decision, but also it has this extraneous prejudicial material in front of it too, just by virtue of the fact that it was given to the IAA. Did that mean that the IAA, in reaching a decision affirming the delegate's decision without reference to this, violated the bias rule? Well, to start with, the High Court simply reaffirmed that the two-step process earlier explained in the Edna case is still there, and that's the way you proceed with a bias case. You've got that on your PowerPoint. I won't go through those two steps. They're the basics for applying the ostensible bias test in natural justice. But the High Court then split 3-2 as to whether or not the bias test was satisfied in this particular case. And this is where the contention arose, if you like, in this 3-2 split. The minority, first of all, said that, look, a fair-minded lay observer should be taken to understand that the IAA was a professional decision-making body. It was capable of realising that this material in the file was not relevant to what it had to do and could put it aside without being affected by it. The fair-minded lay observer would understand that this wasn't an attempt by the Secretary of the Department to delegate a view, to present a view to the IAA about the applicant at all. But the joint majority felt otherwise. They said, well, no, when you look at the statutory scheme, the IAA is required to make a decision on the review material. The review material includes the prejudicial material. It's deemed statutorily relevant before it, so the IAA, I guess in a sense, can't escape this prejudicial material that was before it. And on that basis, in their view, the bias test was satisfied. Key issue, of course, was the level of prejudice in the material. I mean, how prejudicial was this material? How do we work that out? How does a court work that out in applying the bias test? Well, Two of the judges thought that the material was not so bad, if you like, that it would play on the subconscious mind of the IAA and lead it to engage in a non-partisan decision. However, the other three judges thought that it was. Two of them said it was definitely somewhat prejudicial. One of the judges, Justice Edelman, described it as quantitatively and qualitatively significantly prejudicial. So it just indicates there can be differences of view in the court about characterising the degree of prejudice involved in the material, which will play on how the test is applied. Standing back from CNY 17, then, in broad terms, as I said, it highlights the difficulty in deciding what level of knowledge you impute to the fair-minded lay observer when you apply the test. It's not easy to determine that. In the past, the High Court has said that the fair-minded lay observer, whilst not a lawyer, is not wholly uninformed or uninstructed about the law in general or the issue to be decided, and is taken to be aware of the nature of the decision-making process in question and the circumstances in which the decision was made, including the differences between judicial and other types of decision-making. So that's what the High Court has previously said, but obviously the problem is still there, which we need to struggle with, and CNY 17 is an interesting illustration of that. Moving on to a ground of judicial review, a difficult ground of judicial review, the unreasonableness ground of judicial review. We have a High Court decision from just a few weeks ago called ABT 17 against the Minister for Immigration. Again, unfortunately, I guess for us, this is a decision involving the highly statutorised fast-track review process under the Migration Act, Part 7AA. And again, I said earlier, it's always difficult to extract general principles of use and relevance to us at the state level for state law from many of these High Court decisions, because they turn very much on the highly statutorised procedure involved in the fast-track review process. But we can draw out some general points of relevance, I think. Now let's have a go at doing that in looking at ABT 17. Firstly, recall, some of you might have been at this talk a number of years ago. In fact, back in 2013, when I did the end-of-year review talk and the Lee case was handed down, and we spent a bit of time talking about that. I thought that at the time that was a High Court decision which I called revitalised Wednesbury unreasonableness, because it breathed new life into the reasonableness, the unreasonableness ground of judicial review. Key point, I think, being that the High Court explained carefully how that is a presumption of statutory interpretation, in the sense that statutory powers are to be exercised reasonably and rationally. The High Court said, take notice, statutory powers which affect rights and interests are to be exercised reasonably and rationally. And if we think they're not, we'll say the decision was invalid. More than that, the Lee case indicated to us that this implied condition of reasonableness is not confined to why a decision was made. It's not confined to looking at the ultimate decision itself and saying, was that decision reasonable in the sense that it was within the area of decisional freedom, in the sense that it was rationally open to the decision maker, or was so outside the box that no reasonable decision maker could have contemplated making a decision of that kind? That's the first type. But the implied condition of reasonableness also applies to how a decision is reached, the process of reaching a decision. Was the decision reached by a process, the court said in this case, devoid of plausible justification. If it is, then you've satisfied the unreasonableness ground, subject to what we'll say about materiality in a moment. So ABT 17 was about the fast-track review process. What happened in this particular case was the IAA was reviewing a decision of the minister's delegate. The delegate had rejected the applicant's application for a protection visa, and in doing so, the delegate had nonetheless accepted part of what the applicant had said as plausible, but rejected all the other parts and came to the conclusion to reject the visa. The delegate had engaged in a face-to-face video recording of his interview with the applicant. And then, of course, the materials are sent up to the IAA for review. So what the IAA had before it was an audio recording of the interview with the delegate. It didn't have a video recording, and it obviously didn't interview the applicant itself in person. The IAA affirmed the delegate's decision, but in doing so, it also departed from that conclusion that the delegate had made in accepting the credibility of a particular part of the applicant's evidence. It rejected the delegate's finding on credibility about that part of the evidence. The challenge was made to the IAA's decision on the basis, in part, of unreasonableness. Was the IAA decision unreasonable in the sense that it departed from the delegate's conclusion about credibility in respect of a component of the evidence? 3 judges, each independently, found that the IAA's statutory duty to review the delegate's decision meant that it either had the choice of accepting the delegate's findings on credibility in relation to that evidence, or if it was going to reject them, it needed to address them and demonstrate why they were glaringly improbable. It didn't do either. It departed from the delegate's finding on the credibility point without any rational reason or explanation. It was therefore, the decision it made, the IAA decision it made, was therefore legally unreasonable, its ultimate decision. But here's where things got tricky. The plurality of 4 judges got there by way of a different route. They said, in essence, that a person's demeanour is critical to a finding of credibility. The IAA did not have the benefit of a visual impression of the applicant when it addressed that question of credibility. That led to what they call an information gap in the evidence before the IAA. How could it have dealt with the information gap? Well, it could have exercised those powers that it's got, which back referred to, I think back in the earlier slide, of obtaining new information which is relevant to the review and which was not before the delegate, if it deems it necessary to do so. So the plurality of 4 said, well, the IAA could have exercised that statutory power and obtained and called the applicant in for an interview and overcome the information gap on that basis. So in other words, it's interesting in that it applies the unreasonableness ground to powers that were available to the IAA which it didn't exercise, but which it should have exercised in order to overcome the gap. I think that's probably a more cumbersome way of going about the process, but that's what happened. And so 3 judges found on the simple approach, 4 judges found the other way. The High Court also addressed the question of materiality, which is something that we've spoken about in the past. The materiality question is attached to the doctrine of jurisdictional error. If a finding of unreasonableness leads to jurisdictional error, then you've still got to address materiality. Here's where there's a difference of view on the High Court. Some judges say that materiality is part of the doctrine of jurisdictional error. In other words, even after you find that a jurisdictional prerequisite to the exercise of the power is not complied with, you still have to determine whether the defect or error was material in the sense of whether it would have made a difference or not. The minority view in the High Court, particularly from Nettle and Gordon, is that materiality is not part of jurisdictional error. You first of all determine whether there's been jurisdictional error, then you consider the question of materiality as part of the separate question of the court's jurisdiction to grant a remedy or not. And you should keep it that way. You should not mix it with the doctrine of jurisdictional error itself. There are a number of reasons for that. They think that's the better approach, Nettle and Gordon, because it indicates more clearly that the executive should observe the rules of the statute, and if they haven't been observed, the onus is on the executive to show why granting relief would be futile. I think it's best not to take that any further. The issue is relevant to us here, and I'll say something about it in concluding comments. I think that the ABT 17 decision indicates that differing view on materiality is still alive on the High Court and hasn't been settled. I want to move on to Queensland Supreme Court decisions, looking at the time, and run through what I think have been some of the key decisions this year handed down by the Supreme Court. Most of them, I think, are in the realm of public sector employment. We've got some public sector employment decisions. I want to bring these ones to your attention because I think they're key decisions on the operation of the Judicial Review Act and the principles of natural justice. Walters and Hanson, I think, is a key decision. It's about a series of suspensions made against the medical practitioner under the Public Service Act. This particular decision, the part I want to focus on is one of the suspension decisions which suspended his scope of clinical practice. That relied on a credentialing procedure document set forth in expected standards. The point about this decision is that it relates to the extended definition of enactment under the Judicial Review Act of Queensland. Remember that if you want to engage the Supreme Court's jurisdiction under Section 4A of the Judicial Review Act, you've got to show that there is a decision of an administrative character made under an enactment. In this case, the key requirement was enactment. Was this decision, this particular suspension decision, made under an enactment? Well, that takes you to the extended definition of the word enactment in the Judicial Review Act. That was the key important part about this decision. The Judicial Review Act says enactment includes the reference made or means an act or statutory instrument. And then Section 7 of the Statutory Instruments Act contains an extensive definition of statutory instrument. I won't read it out here, but if you look at paragraph 134 of the decision, you'll see it set out there. Statutory instrument is an instrument that's made under an act or another statutory instrument, and it must be one of the following types: a regulation, an order in council, a rule, a local law, a bylaw, a standard of a public nature, a guideline of a public nature, and the list goes on. Was the credentialing decision made under that extended definition of enactment? the Supreme Court concluded that it was. They said that the credentialing procedure was either a standard or a guideline of a public nature, and possibly also a rule, the judge said, so that it fell within the extended definition of enactment, and that therefore meant that judicial review of that credentialing decision was available before the Supreme Court, along with the other statutory suspension decisions that were made. That's the key point about that particular decision. So that will draw our attention to looking closely at the source of the power to make the decision in question in these public sector disciplinary decisions. Walters and Hanson 2020, I mean, there are a number of earlier Walters and Hanson or Walters decisions, but Walters and Hanson in 2020, this particular one, also made a point that's worth keeping in mind, that a statutory suspension decision, whenever those powers under Section 189 or 190 or 137 of the Public Service Act are being exercised to suspend a person, they'll only be validly exercised where the period of suspension is specified. That's just a little point to be careful about from that decision that was made there. Investigative reports. When do investigative reports qualify as reviewable decisions? If you look down on the bottom of that PowerPoint screen, you'll see this has been an ongoing issue which we've spoken about in previous years through those cases, Vega and Vega, Worth, an earlier Walters and Drummond. Essentially, the focus is on Section 6 of the Judicial Review Act that provides that if an Act makes provision for the making of a report or recommendation before a decision is made, the making of the report or recommendation is taken to be a decision. When will that generally operate? Well, as those earlier cases we talked about in previous years demonstrate, that applies where the statute in question provides for the making of a report and provides that the making of that report is a condition precedent to the making of a subsequent decision to either, for instance, dismiss a person or suspend them or whatever. That's how Section 6 operates. In the Chibanda case, which involved a trial judge decision by Justice Peter Applegarth, and then it went on appeal to the Queensland Court of Appeal, worth taking a look at because the QCA just explained again in reaffirming what Justice Peter Applegarth had said, that you just can't pick up any report made that doesn't have a statutory basis, such as these reports made inside Queensland Health, or some memo that records a report being made, and say that they are reviewable decisions under the JR Act by virtue of Section 6. They're not. You've got to satisfy those conditions that I just outlined earlier. So it's a useful decision to look at because it just rehearses the law in relation to Section 6. That takes us to another one concerning now natural justice, which we spoke about quite a bit last year in last year's end-of-year review. We looked at those decisions, Durante Day and Marsden and others. Braun and Rushbrook, I think, is an important one to look at. It concerned a number of continuing suspensions against a medical officer, again made under Section 137 of the Public Service Act. In this particular case, an argument was put forward that the exercise of the Section 137 suspension power does not attract the rules of natural justice. Detailed arguments were put forward that if you read the Act as a whole, including by reference to extrinsic materials, the better view would be that natural justice is not required to be exercised in relation to Section 137. Reference was made to Section 190, which provides expressly that natural justice is not required if the suspension is on full pay. That's in section 190 subsection 2, by the way. And a reference was made, as I said, to extrinsic materials, particularly the explanatory notes, which indicated that Parliament didn't intend natural justice to apply in relation to the exercise of this particular suspension power. Now, I thought that was always going to be a difficult argument in light of High Court jurisprudence on natural justice and the implication rule. The High Court has always made it very clear that whenever you've got a statutory power with capacity to affect rights and interests, then the implication rule is that it's subject to the rules of natural justice unless that the statute unequivocally and expressly excludes natural justice. So I thought it was going to be an uphill battle running those arguments, and it was. The High Court in this case concluded in lengthy reasons, which are worth looking at, that the Kiowa presumption really meant that the contrary intention not demonstrated at all in this particular case. The Supreme Court pointed out that, as the High Court has previously said in cases like Saeed, there's no point in referring extrinsic material to us about what politicians might have thought they were doing when they passed the legislation. We will read the legislation carefully as it exists today in light of these important common law presumptions, one of which is the one in question here. And unless the statute unequivocally and expressly excludes natural justice, it will be implied. There was also some discussion in this case about what to do in light of the ruling in Waters and Hanson, which we just spoke about, given that that decision was handed down while this case was going on. I'm not focusing on that particular point, but you'll see it when you read the case. But look, I think that's a good decision on natural justice because it rehearses the general arguments about the implication rule. Section 24AA has come up. This is a good one. Been a couple of decisions this year on 24AA. That's what Barry and I call the public officer's friend when we do the statutory interpretation workshops, because that's the provision that allows you to remake a decision. But remember always that your power to exercise 24AA depends on whether the statute that you're working with exhibits a contrary intention, because Section 4 of the Acts Interpretation Act also tells you that the rules in the AIA, including 24AA, are subject to a contrary intention. This is an interesting one because it deals with these new officers, the independent assessor and the councillor conduct tribunal. The independent assessor had referred a matter to the councillor conduct tribunal in relation to the conduct of a particular councillor. There'd been some steps undertaken to begin with as to whether or not, when the councillor's conduct was referred to the independent assessor by the relevant council, whether or not the councillor's conduct constituted misconduct or not. And ultimately, the IA referred the matter to the councillor conduct tribunal for a determination of whether misconduct had occurred or not. After it had done that, the IA then changed its mind and advised the tribunal that in relation to its power to do so under Section 24AA, it was revoking its reference to the tribunal of this matter. It did so by pointing out that it found out that this councillor no longer intended to run for public office next year, and so it probably didn't think there was any point in referring the matter on, and it was doing so. The tribunal responded saying, I'm sorry, but we don't think that you've got power to do that. Once you've activated our jurisdiction by that referral, that's the end of the matter. We are now to go on and determine the matter. because when you look at the relevant provisions of the Act, those provisions of the Local Government Act to do with the independent assessor and the Council of Conduct Tribunal, that will indicate to you a contrary intention that once you've made a referral of this kind, it can't be taken back. And the court agreed with the tribunal's approach. The court pointed out generally that the question is in terms of whether 24AA is available or whether a contrary intention is shown. The question is whether the decision in question is of such a character that it's not exercisable from time to time and cannot be revoked. Now, we've spoken in the past, Barry and I, in the statutory interpretation workshop of cases like firearm distributors, which is a case which indicated where the power is adjudicative in nature and affects rights and interests, you can only exercise it once. You can't revisit it. This is not one of those types of cases, but the court said we're not restricted to those kinds of cases. Let's take a close reading of the Act here. And when they did that, it illustrated that 24AA was not available. For instance, the Act indicated that these powers were intended to reach people who'd left public office. So that put at naught the independent assessor's reason in that respect. They also show that the IA has a number of options. They also show that once an application is made to the tribunal, the independent assessor ceases the role of investigator and becomes a party to the proceedings. And the court said you can't undo that process. You can't then decide you'll step back and just be an investigator again. So there was a contrary intention shown in the Act. Good case to look at for 24AA. There's another good one as well, which I put on the bottom of the screen, which I won't go through in detail, Justice Peter Applegarth's decision in Shelley. That's also a very good recent decision on the 24AA power to revoke a decision. Again, in that case, Justice Applegarth said 24AA wasn't available to the statutory entity to attempt to remake its decision in relation to the engineer in question and to try to deprive him of his licence to practice as an engineer. We better move on quickly because I just want to finish up very quickly with just only a general reference to other kinds of decisions. There have been some decisions that have by the Supreme Court that touch on the Human Rights Act. I don't want to go into them now because Barry and Tim run separate workshops on the Human Rights Act and how it affects people in the public sector. So I will only leave you broadly with the PowerPoints that we have here. The first one just is a general one about the Human Rights Act. The second one is I just draw to your attention that Supreme Court decision in Innes earlier this year about a local government election in which an applicant sought to challenge a local government election in much the same way as the outgoing President Donald Trump is doing at the moment, I guess we could say. Supreme Court in this case said it really wasn't necessary to deal with the issues involved that relate to the Human Rights Act, but did discuss them in detail. So we do have some discussion in the Innes case about how those provisions of the Human Rights Act will operate, particularly in relation to the activities of a court exercising, in this case, judicial review. But in that case, in the Innes case, the court said it really didn't need to be making a decision on that basis because there was no case really to answer in that put forward by the applicant here. So I just also point out two other decisions involving the Human Rights Act where there was a brief discussion by the Supreme Court. And the very final decision on that PowerPoint is one that was handed down just a couple of weeks ago by the Supreme Court in Victoria, which was a challenge under the Victorian Charter of Rights to the curfew provisions of the Victorian emergency legislation, but it failed. in that case on the basis that the Supreme Court's considered that the measures were proportionate. Finally, very, very, very brief reference to Court of Appeal decision in University of Queensland against Y. You'll remember earlier, or late last year, the Supreme Court here, the trial judge concluded that the University of Queensland's disciplinary processes in relation to an action brought against a student for sexual assault was such that it didn't have jurisdiction to proceed because essentially what it was doing was trying a criminal offence. That decision was appealed by the university, and quite recently the Court of Appeal handed down its decision in UQ against Y. Now, what the Court of Appeal did at the end of the day was to reject the appeal because it said the student was no longer enrolled and graduated, so it was pointless. The university didn't have jurisdiction to continue with its processes against the student. But at the same time, the Court of Appeal felt it was necessary to express disapproval with the trial judge's conclusion. And that's a key point. The Court of Appeal disagreed with the trial judge's conclusion that the university's disciplinary procedures were not available in a case like that because the offence being dealt with in question was essentially a criminal offence. The universities will breathe a sigh of relief in relation to that point, I think, because it essentially means that there's not a major flaw in their misconduct procedures in the way in which they proceed. Simply because something can constitute misconduct under a university's misconduct procedures doesn't mean that it's also a criminal offence. The two can operate together. A university determining that misconduct has occurred, student misconduct, is simply deciding on the balance of probabilities that the student code of conduct has been violated. It's not determining that there's been a criminal offence committed beyond reasonable doubt. So that will be, as I say, a relief to universities generally. Very quickly summing up, what are the key takeaway lessons? Putting aside the constitutional questions up front that we dealt with, statutory interpretation is a big one. I think particularly a shift away from what the High Court had previously said in the ASIC case. Secondly, it's hard to extrapolate from the fast-track review processes dealt with by the High Court in the cases I referred to, but note what the court says about the unreasonableness ground and about the materiality issue. In terms of the Queensland Supreme Court decisions we've looked at, public sector disciplinary processes have featured quite heavily. Again, what kinds of decisions are reviewable under the JR Act? Which decisions are subject to the rules of natural justice? The cases touch on those points, I think, significantly and are worth looking at from that point of view. Finally, I think we will see more cases as things unfold in relation to the application of the Queensland Human Rights Act. But as I said, I'll leave those matters to Barry and Tim in the special workshops. That's all we've got time for, folks. Thanks for being available. If there are any questions that arise, then I'm happy to respond to you in writing on those questions, provided you leave some contact details. Thank you very much.